right, we've talked about sales and leases, and just to kind of give you the heads up, this is my third time trying to record this audio. I don't know what's happening with my recording system. It starts to work and then it craps out on me. So hopefully 3 times a charm. So I'm going to note that there's a supplemental handout condensing these rules for title and risk of loss. So you might want to pull that out off of Moodle and have that while you're watching the video. There's also an example sheet to discuss the examples of the concepts that you're going to find in this video and hear about. So title and risk of loss. Anything can happen between the time a contract is signed and the time that the goods are transferred to the buyer's possession. And I also want to, I'm going to stop right there. We've been talking about sales and leases, Article 2, Article 2A. All of what we're going to discuss right now apply to sellers and lessors and buyers and lessees. I'm just not going to keep using them interchangeably. Assume that it also applies to lessors and lessees unless I say otherwise. Okay? So people can contract, for goods, but before the contract is finished, goods can be subject to theft, damage, or destroyed due to intentional conduct or clumsy handling. There's fires, there's floods, there's hurricanes. Acts of gods can destroy these things. And sometimes they just disappear, and people are like, what the heck happened to them? But unfortunately, someone has to bear the risk. And the person who does suffer the risk is called to bear the risk of loss of goods. And the rules of the UCC about the rights and liabilities of the parties to a contract is what we will review. But in most situations, the rights and liabilities are not determined by who has title or the right to ownership, but these other 3 concepts that we call identification, risk of loss, and insurable interest. So we're going to start with identification. In the sale or lease of goods, the express designation of the goods provided for in a contract. That's what we call identification. Before any interest in specific goods can pass from the seller or lessor to the buyer or the lessee, the goods must exist and be identified as the specific goods designated in the contract, i.e. 5,000 widgets. The risk of loss and the title, if it's not a lease, we don't have titles that pass with a lease, cannot pass from the seller to the buyer unless the goods are identified. So the parties can agree in a contract on when the identification takes place, but if they're not, the UCC provides for provisions. And that's going to depend on the goods. So existing goods. We have a contract that calls for the sale of specific goods that already exist. Say, for example, car dealer sells 5 cars bearing 5 VIN numbers of the cars, and the cars are out on the lot. Those are existing goods. So identification occurs at the time the contract is made. Future goods. Goods that are not existing and identified to the contract. For example, unborn animals, crops that need to be harvested, maybe goods that need to be made. So identification will take place with regards to animals upon their conception. For crops that are to be harvested within 12 months or the next harvest season, whichever is longer. So identification happens when crops are planted in that instance. Otherwise, when they're grown. So take, for example, it is January in northern New York. You own a co-op. You want to sell my organic lettuce. I grow from spring until the fall. We make a deal in January, but I don't plant until April, and then throughout the rest of the season. I make a deal with you to buy all the lettuce that season. When does identification happen? Well, it's within 12 months. It's really the next harvest season, but whichever is longer. The identification is going to happen once I plant my lettuce. With regards to other future goods or goods that need to be made, the identification occurs when the goods are shipped, marked, or otherwise designated by the seller as the goods to which the contract refers. So it's in the hands of the seller to designate. Goods from a larger mass. These are marked, what are goods from a larger mass? They're identified when the goods are marked, shipped, or somehow designated by the seller as the particular goods to pass under the contract. So Aaron has a warehouse of 50,000 cases of widgets. The buyer buys 5,000 cases of widgets from Aaron. When do we have identification? Once Aaron removes the 5,000 from the 50,000 and marks them as the identified goods, whether by shipping them or have them marked for ship or just designating them as the buyers. We have an exception to this rule. It's called the fungible goods rule, or rule relative to fungible goods, I should say. Fungible goods are goods that are alike in physical nature or by agreement or by trade usage. For example, oil of like quality and grade, maybe wheat. Mark, Mary, and Madison are farmers. They deposit respectively 5,000 bushels for Mark, 30,000 bushels for Mary, 2,000 bushels for Madison of the same grade and quality of grain in a bin. You can't decide whose grain is whose. It's all in a bin, right? So they call this ownership, they own in common, ownership in common, which means that they each own an undivided interest or share in the whole. So Mark has 50%, Mary has 30%, Madison has 20%. Mark contracts to sell 50,000 bushels of grain to Tony. Can he do that? Yes. Does he have to shovel them all out of the bin? No. Tony will just replace Mark as an owner in common with Mary and Madison. So they all will share in any risk that occurs too, but we'll talk about risk. But that's identification. Once identified the goods has occurred, then we're going to switch to determining when title passes. So passage of title. When does title pass? Under the UCC, any explicit understanding between the buyer and the seller determines when title passes, i.e., so when the parties agree, right? But if there's no such agreement, title passes to the buyer at the time and the place the seller physically delivers the goods. The delivery arrangements are going to determine when this occurs, okay? And I'm noting that this passage of title does not apply to lease contracts because you're not getting the actual title, just getting a right to use it. So types of delivery methods: shipment contracts, destination contracts, delivery, and then we have situations where there is no movement of the goods, but we might have delivery. Let's break it down. Shipment contracts. All contracts are assumed to be shipment unless stated in the contract otherwise. So we're going to be dealing with shipment contracts unless something else is specified. What is a shipment contract? A contract for the sale of goods, which the buyer assumes liability for any losses or damage to the goods on the seller's delivery of the goods to a carrier. So basically the seller has to get the goods to a carrier. The seller is required and authorized to ship these goods or get those goods to a carrier, and a carrier can be a trucking company, air freight, and the seller only has to get them in the hands of the carrier. Once that's done, title shifts to the buyer at the time and place of shipment, and usually the buyer will assume the liability at that point. So on February 1st, buyer orders 5,000 widgets from seller, who agrees to sell and ship them by February 28th. Seller has a warehouse of 500,000 widgets. On February 24th, seller boxes and marks the 5,000 widgets with buyer's address. Seller delivers the widgets to FedEx on February 26th at 8 a.m. Is this a contract? Yes, it's a contract. Does Article 2 govern? Yes, it does. Contract for sale of goods. Are the goods identified? When do they get identified? On February 24th, when seller boxes and marks the 5,000 widgets. That's when the goods are identified. Who has title to the widgets on February 23rd? The seller. On February 24th, who has title to the widgets? The buyer. On February 24th. I'm sorry, doesn't have title. That's identification. The seller has title on February 24th? When does the buyer get title? On February 26th at 8 o'clock or 8:01 when the seller delivers the widgets to FedEx. We'll talk about risk of loss, but the risk will remain with the seller until he gets the widgets to the carrier. And at that point, risk will then shift to the buyer. Our next type of contract, destination contract. A contract for sale of goods in which the seller assumes liability for any losses or damages to the goods until they are tendered at the destination specified in the contract. Under a destination contract, the seller is required to deliver the goods directly to the buyer. Title passes to the buyer once the goods are tendered to the requisite destination with the necessary notice so that the buyer can take delivery. Until then, the seller assumes the title and liability. So on February 1st, Albert in New York City agrees to deliver 10,000 widgets to Bert's warehouse in LA by March 1st. Albert places the widgets on his delivery truck on February 21st, and the truck leaves the loading dock for LA. The truck arrives at buyer's warehouse February 28th and is unloaded by the buyer. So identification of goods happens when? At the time of contract, because here we know that it's 10,000 widgets. Who has title on February 1st? Albert. Who has the risk? Albert. When does the buyer get title to the goods? On February 28th, when the buyer is unloading. And we assume that the buyer received notice because the buyer is doing the unloading in this example. So delivery without moving goods. We have two situations, like when the buyer is picking up the goods or maybe the goods are being stored at a warehouse. We have a situation where the seller has to deliver a document to a buyer and situations in which the seller does not have to deliver a document. What we call a document of title to the buyer. The document of title is paper exchanged in the regular course of business that evidences the right to possession of goods. So let's take this example. Document not needed where the buyer is picking up the goods. So Norton Timber Company sells some lumber to Byron. They agree that Byron will pick up the lumber at the company's sorting yard. What do we need to know? Identification. Do we have any identification here? What exactly is he picking up? We don't know, right? We don't know. So, rule 1. When no documents of title are required and delivery is made without moving the goods, title passes at the time and place that the contract is made if the goods have been identified. So, Byron shows up at the yard and takes 50 boards. When does title pass? When he identifies the 50 boards, when he picks them up. Byron agrees to pick up 100 boards of lumber tomorrow. When does title pass? Title passes at the time of the contract is made, not when he picks them up tomorrow, because we already know it's 100 boards. When they are identified, title passes at the time of the contract. So when there is a document of title required, call it bill of lading. It's a receipt signed by a carrier, or we're dealing with a warehouse receipt, and that's a receipt issued by a warehouse. And our rule is when a document of title is required, title passes to the buyer when and where the document is delivered. Makes sense, right? Title passes to the buyer when and where the document is delivered. The goods are never moving. So if the goods are stored in a warehouse, the title passes to the buyer when the buyer gets the appropriate documentation. Seller stores 100 cords of lumber at warehouse plus. Seller agrees to sell the 100 cords to buyer. Buyer wants the cords to remain at the warehouse because buyer doesn't have room for it at his place. What has to happen for buyer to get title? He has to get a warehouse receipt from Warehouse Plus in order to obtain title. So questionable title. And I don't know how you guys hear the videos. I don't listen to them all the way straight through. I hope they're good quality. I try and listen, but I'm having some trouble recording today. So I'm kind of going slide by slide and stopping and listening and make sure that the recording takes. So hopefully it's good at your end when it all comes out. But anyway, questionable title. We move on. Jim steals a Canon camera owned by Margaret. He sells the camera to Sally, who acts in good faith and honestly was not aware that the camera was stolen. Can Margaret reclaim her camera from Sally? And the answer is yes, she can, because Jim had what we call void title in the camera. And Margaret, despite Sally's good faith and honesty, Margaret can get her camera back. Sally might have some recourse against Jim, maybe sue Jim, but it was Margaret's camera. Jim didn't have legal title. We call it void title. No title exists. Therefore, Margaret can get her camera back. But we all have this other concept here of voidable title. A seller has voidable title if the goods, if he or she is selling, if the goods he or she is selling were obtained by fraud, paid for with a check that is later dishonored, purchased from a minor, or purchased on credit when the seller was insolvent. And what do I mean by insolvent? It's a condition in which a person's liabilities exceed the value of his or her assets, meaning they have a lot of debt. The difference between a seller with void title and a seller with voidable title is a voidable title, you still have the power to transfer good title to a good faith purchaser. Okay? So there's a key there. You could still ultimately transfer a good title to someone who buys in good faith. And who is a good faith purchaser? It's a purchaser who buys without notice of any circumstances that would cause a person of ordinary prudence to inquire as to whether the seller has valid title to the goods being sold. So, for example, seller purchases 10,000 widgets from source on credit. Seller is insolvent. Seller then sells 5,000 widgets to buyer, a good faith purchaser. Seller does not pay for the goods from source, and source wants the goods back. Can source recover from the buyer? That's going to depend on whether or not the buyer is a good faith purchaser. And we'll assume that the buyer has a good working relationship with the seller and doesn't know of any of seller's background or problems. Okay? So buyer, a purchaser, buys without notice of any circumstances that would cause a person of ordinary prudence to inquire as to whether the seller has valid title to the goods being sold. So we're going to assume that our buyer is a good faith purchaser. Doesn't have any information regarding the seller and has no reason to doubt that the seller does not have valid title, despite the fact that the seller gets the widgets, 10,000 widgets on credit from source. In this instance, the answer is going to be no. Source cannot get those 5,000 widgets that were bought in good faith. Now, if the buyer knew about the seller's issue and did so anyway, then they would know about the risk if he knew that they were purchased on credit and the seller was insolvent. So in this instance, there was a voidable title, but because of the transfer was made to a good faith purchaser, that transfer is going to be allowed. I have other examples regarding this rule and the next rule that are on the separate sheet, and the answers will be on a separate video or the analysis that you can look at, but work through those separately and then listen to the audio on those. So now we have a rule that applies to merchants, the entrustment rule. Remember our merchants rule, the special kind of individual, person engaged in the purchase and sale of goods. So this is a rule stating that the transferring goods to a merchant who deals in goods of that kind gives that merchant the power to transfer those goods and all rights to them to a buyer in the ordinary course of business. And I'm noting, and I note on the slide, this includes both delivering the goods to a merchant and leaving the goods with merchant for later delivery or pickup. So let's assume you have a radio that you need to be fixed and you bring it to a radio repair shop that also sells radios, and you're going to pick it up the next day that they're going to fix it, but in the meantime the merchant accidentally sells or innocently sells your radio to someone who comes in to buy a radio. That's where this rule comes into play. So, who is a buyer in the ordinary course of business? A person in good faith and without knowledge that the sale violates the ownership rights of a third party buys in the normal course of business from a person in the business of selling goods of that kind. Again, my example is the radio shop that fixes and repairs radios but also sells radios. That would be a type of business selling goods of that kind. This rule does not apply to pawn shops. Okay? I want to make that clear. Pawn shops don't apply. You have to have business of selling the goods of that kind. Selena steals Jan's watch and leaves it with a jeweler for repairs. The jeweler sells the watch to Ben, who does not know the jeweler has no right to sell it. So against whom does Ben get good title? And can Jan recover her watch? So Ben gets good title against Selena. Selena entrusted the watch to the jeweler, but not against Jan, who neither entrusted the watch to Selena nor authorized Selena to entrust it. But Ben, according to the entrustment rule, who bought the watch in the ordinary course of business from a jeweler who is a merchant, can get good title via Selena. But what about Jan? Can she still recover the watch from Ben? Yes, she can, because between Jan and Selena the title was void. There was a void title. Does that make sense? There's other examples. I'm going to do this example and the other example on the attached sheet, and we'll run through this again in more detail. I'm getting all the rules out there. But if you lose your good to theft, there's no title. You never transferred it. Don't you think you'd have the right to get it back despite the fact that Ben was a good faith purchaser? Maybe Ben has recourse against a jeweler, or maybe even Selena, but Jan would be entitled to recover her watch. There's a concept under property law that we're going to learn when we get to real property called replevin, that you can get your property back if it was taken from you. So in this instance, Jan can recover. Ben may have recourse against the jeweler, but the point of this example is to show you the entrustment rule and how it applies to merchants. So we covered identification of goods, passage of title, and now we are going to turn to risk of loss and how do we determine who bears the risk of loss. As I indicated at the beginning, the question of who suffers the financial loss of the goods that may have been destroyed, stolen, etc. is not necessarily determined by who has title. There are several situations to discuss. As with anything else, the parties can contract as to when the risk of loss attaches or is determined, but when it is silent, the UCC will have a determination, and that's going to depend on if we're dealing with what I call carrier cases, those that are the goods are movable and being delivered, or they're going to be the delivery of non-movable goods, like when the buyer is picking up or if the goods are in a warehouse. Carrier cases. We're going to move on to carrier cases. So the court is, when we're talking about these kinds of cases, or the delivery with movable, or where the goods are movable, the courts are first going to look at the specific delivery terms of the contract. They're looking for the terms to determine which party is going to be paying for the costs of delivery and the goods and so forth. So these are the types of things they're looking for. FOB, free on board, indicates that the selling price of goods includes the transportation costs to the specific place named in the contract. Now, as I said, we have shipment contracts, we have destination contracts, and shipment contracts are what's going to rule unless the contract says otherwise, but this is what courts are looking for. If they see free on board with seller's location, this is going to be a shipment contract, meaning the seller just needs to get the goods to the carrier. It would specify the place and name of the seller. So let's say if we have a manufacturer in Boston who is manufacturing goods that needs to get them to a buyer in Ohio, let's say Cleveland, Ohio, and the court is reviewing the contract and comes across FOB Boston, then we know this is a shipment contract. That's going to be the flag because it says the seller's location. And the only thing that is required is that the seller put the goods in the hands of the carrier, and then the risk will pass to the buyer. Destination contract. If the specified place is FOB Cleveland, then the risk is still with the seller, and it's still the seller's obligation to deal with any risk, and we call that's going to be our that's going to flag us as a destination contract. Other terms we have FAS, free alongside the ship. This is a form of a shipment contract. The seller delivers the goods alongside a vessel in a manner usual in that port or dock designated by the buyer. So this is like shipping by a boat. So the seller just has to deliver the goods to the vessel in the manner prescribed. It would be considered shipment. So once the seller does that, then the risk is going to shift to the buyer. The SIF or C&F, cost, insurance, and freight, or just cost and freight, again, another shipment contract, requires the seller to put the goods in the possession of the carrier, at which time the risk of loss will shift to the buyer. Delivery, X-ship. This is a form of a destination contract. It says delivery from the carrying vessel, which means the goods must be properly unloaded from the ship or carrier, which means it has to get to the buyer. So the destination, this is a destination contract, and the risk of loss remains with the seller. So courts will have to determine what type of shipment or contract that we're dealing with here to determine how the risk of loss is going to be, and they turn to the whether it's a shipment or a destination contract. So, for example, Jones Orchard in Tampa, Florida, sells 500 cases of grapefruit to grocers, fruit brokers, buyer in New York City. The contract states sale is FOB Tampa. The goods are damaged in transit. Who suffers the loss here? What kind of contract is this? It is a shipment contract because the FOB Tampa means our orchard, our Jones Orchard, just has to get the grapefruit in the hands of the carrier. So who suffers the loss here when they're damaged? The New York City grocer. So where we have delivery without movement of goods, remember our Byron in the lumber company example, where the buyer's picking them up or the goods are with a warehouse. Just some couple terms here. We have a bailee, we have a bailor, we have some new names for everybody. So the bailee is the party who, by a bill of lading or warehouse receipt or other document of title, acknowledges possession of goods and contracts to deliver them. Basically, that's what we call the warehouse. This is the bailee. Okay, the bailor is the seller who has the goods, who has the goods situated with the warehouse. So, let's talk about some examples where the goods are held by the seller. We'll get back to our bailee, where you don't need a document of title. Back to our lumber and Byron. Merchant is the seller. So we have some rules if the merchant's a seller or a non-seller. If we have a merchant who's a seller, the rule is that the risk of loss to goods passes to the buyer when the buyer takes physical possession. So back to Byron. Byron contracts to buy 100 boards of lumber on Tuesday. He pays the lumber company $1,000. He picks them up on Thursday. This is a transaction governed by contract governed by Article 2 because it's for the sale of goods. When are the goods identified? At the time of contract, 100 boards of lumber. When did the title pass to Byron? At the time of the contract, because we have the goods identified, 100 boards. Who has the risk of loss on Wednesday? That would be the lumber company, the seller. The seller is a merchant, so the risk of loss to goods held by the seller passes to the buyer when the buyer takes physical possession. So only on Thursday, when Byron picks them up, does Byron, the buyer, have the risk of loss. It's a little trickier when we have a seller who is a non-merchant. The risk of loss passes to the buyer on tender of delivery. And when is tender of delivery? Well, for risk of loss purposes, we also have a complete definition of tender of delivery that we're going to talk about next time under performance and breach. But right now we're talking about under risk of loss. So let's start with this example. Janice agrees to sell her old car to a friend, Tom. Tom gives her a check for the price and she offers him the keys. He tells her that he'll have to come around the following day to pick up the car. Before Tom picks up the car the following day, it's stolen from where it has been parked. So who bears the risk of loss? Was there tender of delivery? Yes, there was tender of delivery. Tom gives her the check and she offers him the keys. At that point, we have a tender of delivery. And he tells her that he'll come and pick him up tomorrow. So who bears the loss? Tom has the risk of loss here. Would it matter who held on to the keys? Whether Tom took them and said, I'll have to pick it up tomorrow, or whether she hung on to them? Nope, doesn't matter. Same outcome. Tender of delivery when she was offering him the keys. Suppose instead that when Janice sold the car to Tom, they agreed that she would have it until the next day, and that Janice said, you can pick it up anytime tomorrow. The keys will be here for you. She says you can pick it up anytime tomorrow. The keys will be here for you. And the car is stolen overnight. Who bears the risk? That would be Janice, because the delivery wasn't tendered because she said that they agreed that they'd pick him up the next day. Would it make any difference if Tom had come at 1 o'clock in the afternoon and it was stolen at 9:30? Would it matter if he came to pick it up at 9:35 and it was stolen at 9:30? What's going to be the tender of delivery is going to be reasonable time for when the deal was made. They didn't set a time for them to pick it up. They said anytime tomorrow. So we're talking about a contract within 24 hours. Is 1 p.m. a reasonable time for Tom to come? Yeah. So in this instance, I think Janice would still be responsible for the risk of loss. She didn't say come first thing in the morning. She said come anytime tomorrow. Goods held by bailee. That's our warehouse. So goods are represented by a document called a warehouse receipt. Our seller is our cosigner. A cosignee is a person who has the right to retrieve goods whenever it wants and must have a document to prove it. So how does this work? Sellers, they have so much stuff possibly. Stuff gets bulky. They don't have their own storage facilities, so they use these third parties to store goods. So when a bailee is holding goods for a person who has contracted to sell them, and the goods are to be delivered without being moved, the goods are represented by this document of title. Okay? So who has the risk? Oh, before I jump in who has the risk, I should tell you there's this one component about documents that we're going to talk about a lot more when we talk about negotiable instruments, but this document may be negotiable or non-negotiable. Okay? If we're talking about the risk of loss, we're talking about a negotiable document, which means it gives it the ability to transfer goods. The document gives the ability to transfer the goods and the rights to the goods when it's negotiable. Okay? So at this juncture, when the goods are held by bailees, the buyer will have the risk of loss when one of the following things occurs. The buyer receives this negotiable document of title saying that they have the goods, or the bailee acknowledges the buyer's right to possess the goods, or 3, the buyer receives this negotiable document saying they have the goods and they have a reasonable time to present it to the bailee to get the goods. If a bailee refuses to honor the document, the risk of loss remains with the seller. So that's the key here on who has the risk of loss when we're dealing with goods that are being held by a warehouse. It's all based on a document and the buyer's receiving of that document or receiving of the acknowledgement by the bailee. Conditional sales. Buyers and sellers sometimes form contracts that are either conditional on either the buyer's approval or of the goods when they get them, or they have them on a trial basis, or the buyer's resale and purchase of goods. Sometimes they might say that you have these goods to resell. If you don't, I'll buy them back. That happens. Sale on approval. When the buyer becomes satisfied with the goods, the buyer will obtain title and risk. So, in other words, the seller retains the title and has the risk of loss from any causes beyond the buyer's control. The buyer can't destroy the goods until the buyer accepts the offer. And then at that point, the buyer will have the title and the risk. So for example, you order Bowflex online after seeing the infomercial. You bought it on a credit card. You are told that you can try it risk-free for 30 days. If after 30 days you keep it, who has the title and risk on day 28? Bowflex, because you're in their trial period. If on day 30 you decide you're going to keep it, the title and the risk then gets transferred to you. What if you file for bankruptcy? You bought this thing on credit card, you file for bankruptcy on day 15 of your trial. Can the credit card come and take your Bowflex to pay your debt, to sell it, and then pay your debt? No. The Bowflex belongs to the seller, or the Bowflex folks. They have the title and the risk of loss in that time period. After that, though, you would be. And where the buyer has goods for resale and has the option to return them. The sale, where the title and the possession pass from seller to buyer, and we have the buyer retaining the option to rescind or return the goods during the specified period, even though the goods conform. Okay, we're not saying that you're just testing them out here. The goods, the buyer agrees to buy the goods from the seller and then resell them on the condition that if they don't resell, then the buyer gets to return them to the seller. We see that with diamond wholesalers. They deliver gems to a jeweler retailer with the understanding that the retailer can return any unsold gems within a time frame. I put 6 months, but within an agreed upon time frame. Who bears the risk, though? I think this one kind of makes sense if you think about it. Who bears the risk? Well, at the time of the sale, we got the title and the risk passing to the buyer because the buyer does buy them, right? And both of those, the title and the risk, remain with the buyer until the buyer returns the goods to the seller. And then at that point, the seller will have title and the risk from there. But I'll also note here that the return of the goods is at the buyer's risk and expense as well. So getting them back to the into the seller's hands is on the buyer, and will still have the risk and expense. So what happens when there is a breach of contract? Who bears the risk of loss? We are going to talk about instances of breach of contract and seller's obligations, buyer's obligations. Right now we're talking about the risk of loss when there is a breach. Generally, when there is a breach, the party in breach bears the risk of loss. Okay? David orders 100 blue iPhone cases from Nikki. Nikki, the seller, sends 100 red ones. Is there a contract? Yes. The acceptance on Nikki's part was sending 100 red ones. It's covered by Article 2 because it's sale of goods. Is there a breach? Yes, she sent red instead of blue. So let's talk about this. If the red cases are damaged in any way, who has the risk of loss? The seller. They sent the wrong ones. Why would the buyer have any risk, right? There is this concept called cure. We're going to talk about it under breach. There is a time where a seller can cure the defect, and that curing will fall on the risk of the seller until it's cured. We'll talk more about that. If David, though, keeps the red ones, who gets the risk now? What if he says that's okay? Now the risk shifts to David. When our buyer breaches, as I said, the risk of loss immediately shifts to the breaching party. So in this case, it would shift to the buyer, but there are some limitations on that. The seller must have already identified the goods under the contract. The buyer bears the risk for only a commercially reasonable time after the seller learns of the breach. And then what is commercially reasonable depends on the circumstances. And then the buyer is liable only to the extent of any deficiency in the seller's insurance coverage. Okay? That is how the risk of loss is going to work when there's a breach by the buyer. I have examples on the separate sheet to review and work through that example here. It'll take too long to do it here. might want to do it separately. Look at it, look at this rule, and work through it on your own, and then listen. So then our third component of determining rights and liabilities is the insurable interest. What is it? It's a property interest in goods that is sufficiently substantial to permit a party to insure against damage to the goods. Right? Parties can obtain insurance coverage against loss and damage. I own a car. I have insurance on it. I have an interest in my car because I own it. Right? You can't get insurance on my car because you have no interest in my car. So we have to have an interest in the goods. What is that interest? We're not going to delve into insurance law right now, but or at all. But the UCC has contained some certain rules relative to when buyers and sellers can obtain an insurable interest. So when can they? Buyers. A buyer has an insurable interest when the goods are identified. They have an insurable interest in identified goods. Need to know what the goods are. As soon as the goods are identified, the buyer has an interest in the goods and can obtain insurance coverage. That's even before the risk of loss attaches. So take this example. In March, Hillcrest Farms sells a cotton crop that it hopes to harvest in October. After the crop is planted, Simpson Textiles, the buyer, insures it against hail damage. In September, a hailstorm ruins the crop. Simpson files a claim under its insurance policy. The insurer, Liberty Insurance Company, refuses to pay, asserting that Simpson has no insurable interest in the crop. Is the insurance company correct? When do we have identification for crops? Within 12 months or the next harvest, whichever is longer. So we got March, sells a cotton crop, it hopes to harvest in October. The crop is planted. Then we have the hailstorm. Do we have identification? When do we have identification? When the crops are planted. So here, they're planted, even though they didn't come up. They didn't grow because they got damaged by hail. Insurance company liable. Does the buyer have an insurable interest? Yes, because they're identified at the time planted. This was a real case, and the insurance company lost and had to pay out. So when does the seller have an insurable interest? As long as they retain title to the goods. Okay? As long as the seller retains title to the goods, they have an insurable interest. If they pass title to the buyer, but they hold a security interest in the property, they can still have insurance. We're not going to delve into security interest right now. That's going to be another topic. But you just need to know that as long as they retain title.